Welcome to It's Your Money. I'm Deborah Uroda, and I have Charles Spence in the studio with me. He's a partner with Maynes, Bradford, Sheftel law firm. Today we're going to talk about trusts. What are trusts?
Well, trusts can come in many different forms. They can be complex, they can be simple, they can take effect during your lifetime, they can take effect upon your death or passing. I've often seen the analogy with respect to trusts of a container that holds assets. And it could be any number of assets you have: investments, cash, checking, savings, real property. And it's important to note that with a trust, you have three parties. You have your trust creator, who's your trust settlor, grantor. You have a trustee who manages the assets on behalf of the beneficiary of that trust. The beneficiary themselves is the third party, and they are the ultimate recipient of the beneficial interest, the assets of the trust.
And why would you do a trust?
Well, there are a number of different reasons. Control is often the main issue, I would say, because you may have specialized issues with respect to the assets that you're transferring into the trust. You may have interesting issues with respect to the beneficiaries and how those assets need to be managed within the trust for their benefit. There could be maturity issues, there could be creditor issues, divorce issues, all of which the trust can be structured to deal with.
Okay, that makes a lot of sense. So, for example, if I had a minor child and I was getting ill and I was afraid I was going to die before the minor child came to age, putting my assets in a trust to be managed on behalf of that child would probably be a good idea.
It is, and I think that that's usually you will see some kind of provision for a trust for a minor child, either in a will or a separate standalone trust.
One of the other ones that you have here is it provides privacy. I never realized that before.
It does. I mean, often trusts have been really pushed for the concept of probate avoidance, and so any assets that are within the trust are not subject to the probate court. If you have assets in other states, you may want to try to avoid a probate in that state, so it's good to have those assets in a trust as well. The privacy comes into play because those assets that are in the trust are not subject to the supervision or oversight of the probate court, and they should not be. And so there may be some additional protections if you don't necessarily want to file documents outlining your assets to the court.
Right, so it's not a public record.
That's correct.
Okay,
yes.
Now tell me about what kind of power you have over the property that's in the trust. Can you put assets in and take them out?
You can. I mean, you create a living trust. As long as you are alive and have capacity, you can take the assets back out at any point. I mean, there are specialized trusts, irrevocable trusts, in which your rights would be restricted, but there are very particular reasons why you would create an irrevocable trust, maybe for governmental assistance programs or tax-related reasons. So you need to be careful with that, but generally speaking, yes, you can take them out.
So there's a lot of reasons that you should consider a trust, but you might want to check with your attorney or financial advisor to help you sort through all the options. In the meantime, thank you very much for joining us, Charles. We really appreciate it, and we hope to see you soon.